You are at the 36th District Court. You are at 36th District Court. You are at 36th
Where are we,
District
Judge?
Court. You are at 36th District Court.
Okay. We're not really in the 36th District Court. This is Attorney Mike Gravel coming to you from Chicago as usual, and we're going to court actually in Washington, but we might go visit the 36th District Court on some old video clips for some consultation as we proceed. Let's do it.
Couldn't do anything.
Okay, and we have Mr. Box back. Okay, and Mr. Box, you've had an opportunity to meet with your attorney and Ms. Pitts regarding arraignment. How would you like to proceed today?
We'd like to proceed, Your Honor, with a not guilty plea, waiving formal advisement of rights and formal reading of the charges, and then address conditions of release, if any.
Okay, and probable cause in this matter is established. We'll enter a not guilty plea. And Ms. Trogstad, regarding the state's position on conditions of release, please.
Your Honor, the state is requesting standard release conditions for this case.
Okay, I just skipped to the good part, so I'll give it to you. He's charged with DUI, he's waiving the formal reading, and all the fun, of course, gets down to the conditions of release. I know from prior videos that this is going to make some of you crazy.
Okay, thank you very much. And Ms. Pitts, regarding release?
No objection to those.
Okay. All right, Mr. Box, given the nature of the allegation against you of the DUI at this point, the court imposes what's called release conditions or rules that you need to abide by while your case is pending. I reviewed the probable cause statement, and there is an allegation of a collision in this matter, but I've also reviewed your criminal history and your warrant history, and I see that this is the only matter pending in the state of Washington, and nothing is being reported out of state, sir. And I see that you do not have any warrant history, all things that the court needs to take into consideration when setting release conditions. So, sir, your release conditions under Court Rule 3.2 are to be as follows. I'm going to release you to the administrative level of pretrial release, which means that you're going to have some phone check-ins while your case is pending, but you do not need to post any bail or bond in this case. You'll need to obey all laws, maintain contact with your attorney, appear at all scheduled hearings required by the court. Your next court date is May 17th at 8:30 in the morning. That will be in front of Judge Langsdorf. You are not to consume or possess alcohol, marijuana, or any non-prescription medication while your case is pending. And in addition, sir, I'm going to
And there's the whole problem. This judge does a really good job. In fact, I really like how she stays on point and doesn't get sucked into any of the stuff that he says coming up. But I do miss some of the flair from the 36th district, and since I did a video with similar issues, I might have to refer to our good friend Judge Lynise Bryant.
And in this column that said, medication, it said marijuana. I said, this is some mess right here. Now, y'all know marijuana ain't curing everything. Come on now. They've been smoking weed since the beginning of time almost. Now, in the 70s, people was dying left and right of stuff. They was smoking weed. Like, now y'all not going to act like this with y'all lying. Y'all just want to be high. But, okay, okay, I know I'm a lone voice crying out in the wilderness, but
require you to install ignition interlock device in your vehicle within 5 business days of today's court date and provide proof of doing so to pretrial release. So the same folks that you're calling and getting set up on a schedule, you'll need to provide proof of the ignition interlock device to them as well. Sir, do you have any questions about your release conditions or your next court date?
So you said I can't, you said no drinking, no alcohol, no drinking, no, I don't smoke weed anyway. But the thing about it is, I eat marijuana candy because of the pain in my back from me getting hit by a car. And that's the only thing that actually helps with my pain for me to relax. If not, like my back and stuff would I'd just be all messed up.
Maybe when you high, you don't be thinking about your mental health. That's not treatment. That is not treatment. Okay.
And like I was talking.
Okay, so I only say this because it came up in the comments when this issue was on other videos, and I know it'll make a lot of people crazy. But part of the terms of release are that he can't drink and he can't have marijuana. And it turns out he's got a medical marijuana card. And I know that's going to make some people crazy. But you know what? Drinking is legal, too. And he's restricted from that. The judge gives her rationale for it. But this is where the fun starts.
To the lady earlier, I'm going through a thing right now with disability because of that, because I can't stand up a long period of time because my back tends to like spaz out and gives out sometimes. So the weed candy actually helps me, and I have my marijuana card for Oregon and everything.
It burns me up. I was on TikTok the other day. You can get lost on TikTok. I'm not trying to advertise for TikTok. Sometimes I need comic relief, and I go on TikTok.
Okay, so is this CBD or is it THC as well?
THC is the only thing that helps. CBD doesn't do anything for me. Like I've tried it, but nothing.
All right. I don't even know the difference between CBD and THC other than if it's anything more complicated than THC, gets you high and CBD doesn't. Let me know. But there are a lot of people who are focused on this sort of thing. I think she's asking for the reason that if he was saying it was CBD, she would say fine. But if it's THC, she's not allowing it.
Actually helps, but that.
Right. So the whole point, sir, is that you've been charged with driving under the influence. I understand that this is an alcohol related charge, but the issue is, being under the influence really of anything at this point. So the court's order at this point is to not consume or possess alcohol, marijuana, or any non-prescription medication. This can be brought back before the court. Give the information that you have, to your attorneys, and we can address a release condition at a later time. But at this point, being the infancy stage of your proceeding and what's before the court today, that's the court order. I understand what you're telling me, sir, but.
I really like, actually, both the defendant and the judge are hitting this head on. I will give them this. He says, look, I still want to use marijuana, specifically the kind with THC. He does not duck it. He's very honest and straightforward with her. She does not duck the issue. She comes right back with, no, what we're worried about is you being altered and driving a vehicle. And therefore, I'm going to prohibit it for now. So it's kind of a break from our usual. It's not a sovereign citizen or someone being disrespectful or crazy. He's making a fine argument to the extent he's making an argument. I want to use this for medical purposes. I'm not hiding it. And she's saying, you can't do it, even for medical purposes. And I'm not hiding it. It's refreshing.
Given the nature of the allegation, that's the court's ruling for today. Okay.
So I just have to be in pain, basically.
So, sir, again, you can provide this information.
So I just have to be in pain. That's it. That's his argument. That's what people are going to say. That's what I'm going to hear. Tell me below if you think this judge should allow him, because he does have a medical marijuana card. Do you think she should ease that restriction, or if she's correct in keeping him restricted on that?
To your attorney.
Hi, this is Ali with the Sovereign Citizen Patrol, and thanks to all your generous support, I'm getting belly scratches. So please remember to hit like and subscribe so I get some more.
And it can be brought before the court on a motion to amend your release conditions, but given the nature of the allegation against you, what the concern of the court is at this point is that you would be driving under the influence if it's marijuana or alcohol, even having a card for that in the state of Oregon. That,
but I
in
only
a way,
take that when I'm at I mean to cut
Sir,
you off.
I understand, sir, but this is the court's order. Okay, so you need to give that information to your attorney. They can provide a motion to the court with all the information that you're telling the court with actual, a proper motion with documentation for the court to address that in the future. But for right now, this is the court's order.
Again, I think they're both very straightforward. I understand that people are going to say, well, that's medical use and he needs it, and the court should not be restricting that. She is looking at it and saying, look, our goal for the condition of release here is that you're not driving while intoxicated. That includes alcohol or marijuana. And that's what you've been charged with, and we want to make sure that doesn't happen. She's very explicit. I'm aware of those two competing interests. I'm choosing safety of having you off the road while intoxicated. But she even leaves it open. Like I may even revisit this, but have your attorney file a proper motion.
Do you want to have us send to your attorney your paperwork from the court, or would you like to come back upstairs and receive it, sir?
She can get it too, but I would like to come up and get it myself.
Okay, that's fine. So we'll send it to your attorney, and we'll also have a copy printed out for you here in the same courtroom that you were in earlier before, sir, and we'll have your copy for you.
All right.
Okay, thank you very much, sir. Ms. Pitts, thank you so much. Ms. Trugg said thank you. That concludes our docket.
Thank you, Your Honor.
Well, there you have it. I'm getting ready for the firestorm in the comments. It's probably second only to my tint rant, where people are, to this day are giving me the the advantages of tint. I tend to be on with Judge Bryant on this, that I think it's overstated. I think it's totally appropriate for them to say no alcohol or marijuana. There are other ways to relieve pain, and I don't think that's the exclusive thing that allows him to function. I'm not a doctor. I could be convinced. I could be convinced by the right doctor if I'm the judge, but I would do what this judge did. I need that. I need that clearly articulated, and I have to be convinced. And frankly, I'm leaning against it from the get-go, because the larger interest here as a judge is to keep you off the road while intoxicated. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.